Hello बच्चों, let's see passage one. Passage one talks about criminal cases can be divided into two types. एक होता है समन केस, दूसरे होते हैं वारंट केस. अब ये दोनों में डिफरेंस क्या है? Let's see. एक समन केस can relate to the offense not being a warrant case. Warrant cases are those which include offenses punishable with death penalty, punishment for life or imprisonment exceeding more than 2 years. तो imprisonment 2 साल से ज्यादा या तो death की penalty होगी. So the criteria that differs a summon case from a warrant case is determined by the duration of the punishment. So basically determining criteria है duration of the punishment of the offense. Examination of witness is an important principle in which witness take a stand of his or her words. For protection of its integrity of the evidence, it is very important for a part of criminal and civil trial. It is not important only for the law students, it is also important for practicing lawyers to know the art of law, to know the art and the law related to examination of the witnesses. Examination of witnesses in warrant case. तो अब हमने देखा warrant case और summon case कैसे difference होते हैं, तो अब उसमें examination of witness भी different होगा. तो examination of witness in a warrant case is given under section 242 subsection 2 where the magistrate on the application of the prosecution has the authority to issue summon to witness and direct them to attend or produce any document or thing relevant to the case. The cross-examination by the defense is allowed by the magistrate before some other witness has been examined. तो क्रॉस एग्जामिनेशन का मतलब क्या होता है? बेसिकली कि एक बार आपने उसको पूछ लिया, फिर आप उनके फैक्ट्स रिइटरेट करवाते हो घुमा के क्वेश्चंस पूछ के. This is done that no perjury is committed and the prosecuting witness do not willfully the accused and get him convicted on false information, and the relevant information can be refuted by the defense or further explained in a defensive manner. Section 243 subsection 2 describes the process of examination of witness for defense of the accused, and an application can be made by the defense to the magistrate to compel the attendance of the witness for the purpose of examination or cross-examination or for the production of relevant documents or other things. तो इसमें basically जो defense का prosecution का एग्जामिनेशन का प्रोसेस होता है वो विटनेस के एग्जामिनेशन का वो थोड़ा अलग होता है. उसमें बेसिकली जो डिफेंस है वो कंपेल करता है विटनेस को कि आप अटेंड करो प्रोसीडिंग्स, क्योंकि हम आपको एग्जामिन या क्रॉस एग्जामिन करने चाहते हैं. तो उस केस में मैजिस्ट्रेट शैल इशू direction unless he feels the application has been put for the purpose of delay or vexation or the defense defeats the end of justice and refuse the application on those ground. तो ये जो एप्लीकेशन ऐसा नहीं आपने फाइल कर दिया तो अब विटनेस आ ही जाएगा. मैजिस्ट्रेट उसको एग्जामिन करेंगे और अगर उनको लगता है कि आपने ये सिर्फ प्रोसीडिंग डिले करने के लिए या सिर्फ पूरा जो केस का पर्पस है उसको डिफीट करने के लिए, जस्टिस से दूर रखने के लिए ये सब फाइल किया है, तो वो रिजेक्ट कर देंगे इन ग्राउंड्स पे. द ग्राउंड्स ऑफ रिफ्यूजल ऑफ द एप्लीकेशन बाय डिफेंस shall be recorded by the magistrate in writing. तो कोई भी आप अगर कोई भी रिजेक्शन करते हैं मैजिस्ट्रेट तो उनको इन राइटिंग सब कुछ देना पड़ेगा. However, if the accused has had an opportunity to cross-examine a witness presented by the prosecution or already has been cross-examined a witness, then the attendance of such witness shall not be compelled under this section unless the magistrate feels such attendance is necessary for justice. तो अगर एक बार हो चुकी है और आप दोबारा बुला रहे हैं तो जब तक वो जस्टिस के लिए रिक्वायरमेंट नहीं है मैजिस्ट्रेट उनको नहीं बुलाएंगे. Subsection 3 mentioned that the reasonable expenses incurred by the witness in attending court for the purpose of trial must be deposited in the court. Let's see the questions. Question number 1 says, in the context of the criminal cases, the examination of witness plays a crucial role in ensuring justice. Based on the information provided in the text, consider the following scenario and choose most appropriate option. So, scenario is, in a warrant case, there is an accused which is facing potential life imprisonment. The defense seeks to cross-examine a key prosecution witness. The defense argued that the witness testimony is essential for the case outcome. However, the magistrate is hesitant and wants to evaluate the application critically. The prosecution opposes the cross-examination claiming that it may unduly delay the trial. Which of the following statement is correct regarding the magistrate decision in the situation? Let's see. A says the magistrate must grant the defense request for cross-examination without further inquiry. This is a wrong option because the passage clearly states that magistrate will inquire and look upon whether the application made for the cross-examination is really required for to meet the ends of justice or not. B says magistrate can deny the defense request based on the prosecution's objection alone. This is again a wrong option. Just because the prosecution is objecting, the magistrate cannot deny on the request. The magistrate can very well deny after consideration if he feels that the application has been put to delay. C says the magistrate should consider whether the cross-examination is necessary for justice and must record the ground for refusal if denying the request. This is an absolutely right option because ये नहीं बोल रहा है कि reject करना चाहिए या accept करना चाहिए. It says कि अगर justice के लिए required है तो आप accept करिए, but अगर आप reject कर रहे हो तो आपको grounds very well in writing में record करना पड़ेगा. D says magistrate decision should solely be based on the potential expenses incurred by the witness. This is again a wrong option. Second question says in the legal context of criminal cases, it is essential to differentiate between summon and warrant cases. Which category is based on the potential punishment of the offences involved? Summon cases typically relate to less serious offences while warrant refer to more serious. To better understand this distinction, which of the following statement correctly explains the criteria for classifying cases? A says summon cases encompasses offences where the accused faces punishment exceeding 2 years, including life imprisonment. This is a wrong option because it is stating opposite. The warrant cases have this condition, not summon cases. B says warrant cases apply to any offences that could result in imprisonment regardless of the duration of sentence. This is again a wrong option because the duration of the sentence is important for the cases to be decided at summon or warrant. C says summon cases pertain to offences with potential penalties of 2 or less years. This is the right option because summon cases वही होते हैं जिसमें 2 या 2 साल से कम की सजा होती है, whereas अगर 2 या 2 साल से ज़्यादा की सजा है तो it is more like warrant case and not summon case. D says warrant cases are exclusively capital offences. This is again a wrong option. It is not merely limited to the death penalty. Third question says let's consider a scenario involving classification of criminal cases as summon and warrant. In a situation where an individual is accused of committing a crime, the offence they are charged with carries a potential punishment of 3 years of imprisonment. The defence argues that the case should be classified as summons case, while the prosecution insists it should be categorized as warrant case. In the light of potential punishment and criteria of summon and warrant, which category should this hypothetical case fall into and why? So basically इस case में potential punishment दी हुई है 3 years की imprisonment की. So let's see the option. A says this case should be classified as summon case because the potential punishment do not exceed 2 years. This is a wrong option because here punishment do exceed 2 years का criteria. B says this case should be classified as a warrant case because it involves a potential punishment of 3 years. This is the right option because we already have read in the passage that any offence which has a punishment of more than 2 years is a warrant case, while the other one is the summon case. C says the case may be categorized as either depending on the court's discretion. Again a wrong option. It is not court's discretion but the legislation. D says this case cannot be categorized based on the punishment. This is again a wrong option. Let's see the fourth question. It says consider a hypothetical criminal case where an individual is accused of serious offences that carries a potential punishment of 10 years of imprisonment. The defense believes that the case should be categorized as a summon case while the prosecution argues it to be warrant case. तो यहाँ पे punishment दी हुई है हमको 10 years, तो we all know that it should be a क्या होना चाहिए warrant case because यहाँ पे जो हमारा punishment का time period है वो 2 साल से ज़्यादा है. If it is more than 2 years, it should be a warrant case. So let's see the options. A says yes, this should be classified as summon case. Straight away a wrong option because it is a warrant case. B says no, this cannot be classified as a warrant case because the potential punishment is 2 years. This is an absolutely right option क्योंकि हमको क्वेश्चन पूछ रहा है कि क्या हम इसको summon case बोल सकते हैं, अगर हाँ तो क्यों, अगर ना तो क्यों. तो हम यहाँ पे बोल रहे हैं कि नहीं बोल सकते इसको summon case केस क्योंकि इसकी पोटेंशियल पनिशमेंट 2 साल से ज्यादा है. सी सेज यस, तो दिस इज अगेन अ रॉन्ग ऑप्शन क्योंकि बोल ही नहीं सकते समन केस. डी सेज नो, द पोटेंशियल पनिशमेंट इज नॉट सोल determining factor, other factor needs to be considered as well. This is again a wrong option because पनिशमेंट बहुत इंपॉर्टेंट फैक्टर होता है जिस बेसिस पे सामान्य वारंट हम डिसाइड करते हैं. लेट्स सी द लास्ट क्वेश्चन. इट सेज इन अ फिक्शनल क्रिमिनल केस एन अक्यूज्ड इंडिविजुअल इज चार्ज्ड विद द ऑफेंस दैट कैरीज अ पोटेंशियल पनिशमेंट ऑफ 1 year ऑफ इम्प्रिजनमेंट. तो यहाँ पे जो 1 ही साल की इम्प्रिजनमेंट की बात की गई है. द डिफेंस इज एडमेंट दैट द केस शुड बी ट्रीटेड एज अ वारंट केस while the prosecution argues it to be categorized as summon case. Considering the nature of offense and potential punishment, which classification is appropriate and why? Let's see the option. तो हमें बोलना है कि summon है या warrant. So we know because punishment is less than 2 years, so it will be summon case. तो हमें reasoning check करने की कौन सी सही है. A says this case should be classified as a warrant case because potential punishment indicates the seriousness of the offense. दिस इज अ रॉन्ग ऑप्शन क्योंकि पनिशमेंट 2 साल से कम की है तो इसलिए हम इसको वारंट केस बोल ही नहीं सकते हैं. बी सेज दिस केस शुड बी क्लासिफाइड एज अ समन केस बिकॉज द पोटेंशियल पनिशमेंट इज ऑफ 1 year ऑफ इम्प्रिजनमेंट. ये देखो दिखने में हमको सही आंसर लग रहा होगा कि ये बोल रहा है कि पोटेंशियल पनिशमेंट 1 साल की है तो इसलिए अब ये समन केस होना चाहिए. बट दिस इज अ रॉन्ग ऑप्शन क्योंकि समन केस में पोटेंशियल पनिशमेंट कम से कम मतलब बैक्स इट कैन गो 2 years. ये प्रेजेंट केस की बात किया गया है कि 1 year है तो हम ये नहीं बोल सकते कि समन केस एज अ होल की पोटेंशियल पनिशमेंट 1 year है. सो दिस इज अ रॉन्ग ऑप्शन. Keep this small details in mind. C says this case can be categorized as either. Again a wrong option. It cannot be classified as either. Last says it can be classified as a summon case because the potential punishment is less than 2 years. देखो ये बहुत इंपॉर्टेंट चीज है कि हमें जो क्राइटेरिया है वो परफेक्टली मेंशन करना है. तो जो समन केस का क्राइटेरिया है कि उसमें लेस देन 2 years होना चाहिए. अब वो 1 year है, 1.5 year है, 1 year 11 months भी है तो भी वो समन केस ही होगा. तो ये इंपॉर्टेंट है कि वो लेस देन 2 years होना चाहिए. उसके अलावा जो भी है इट इज नॉट ऑफ आवर कंसर्न. सो ऑप्शन नंबर डी इज द राइट ऑप्शन. सो आई होप द पैसेज वाज अंडरस्टैंडेबल. ऑल द वेरी बेस्ट.